If you've got a specific legal question or situation you'd like to see covered here, drop it in the comments, because that's genuinely where a lot of future topics come from. I read them, and some of the most useful specific videos on this channel started as exactly that kind of comment from someone dealing with a real situation, so don't hesitate. Whatever it is, I'd like to hear it. All right, let's keep moving. There's a moment that happens faster than most people realize, and it almost always catches them completely off guard. You're somewhere, maybe in your car, maybe on a sidewalk, maybe standing outside a store or sitting on a park bench, and an officer approaches, and one of the first things out of their mouth is some version of, "You're being detained." And the entire situation changes in that exact second, except most people have absolutely no idea how it changed, what it means legally, what they're now allowed to do and not do, and critically, what they should say or not say until they understand exactly which category they've just been placed in. That gap in understanding, that space between hearing the word detained and actually knowing what it means, is one of the most legally consequential moments an ordinary person can stumble into, and the cost of stumbling can be enormous. Not because the law is complicated exactly, but because nobody ever sat down and explained the real difference between being detained and being arrested, what each one actually requires, what each one actually allows, and why that single distinction changes everything about how you should respond in the moment it's happening to you. Here's what I want you walking away from this video knowing so completely that it comes back to you clearly even under pressure. Detained and arrested are not the same thing. They are not interchangeable. They do not carry the same legal weight or the same obligations. And the entire strategy for protecting yourself in each situation is fundamentally different depending on which one is actually happening. Confusing them, or treating them as variations on the same basic scenario, is one of the most common and most costly mistakes people make in real interactions with law enforcement, and it happens constantly, not because people are careless, but because almost no one outside of a law school classroom has ever had this explained to them clearly and completely, in plain language, from beginning to end. Before we get into exactly what these distinctions mean and exactly what you should do in each situation, if you want to actually know your rights instead of piecing them together under pressure in the moment you need them most, subscribe right now, because that's precisely what this is here to give you. One more quick note before we start. This is legal education and commentary, not legal advice for your specific situation, and some details shift state to state, but the core principles we're about to cover hold up almost everywhere in this country. Let's get into it. Let's start at the very foundation, because everything else in this video is built on top of this one core understanding, and it's worth getting it exactly right before we go anywhere else. The Fourth Amendment to the Constitution protects against unreasonable searches and seizures. That word seizure is important, and it applies not just to objects and property, but to people. When law enforcement stops you, detains you, or takes you into custody, that is a seizure in the constitutional sense, and that means the Fourth Amendment's protections apply to it directly. But the Fourth Amendment doesn't say all seizures are forbidden. It says unreasonable seizures are forbidden, and the entire legal framework around detention versus arrest is really a framework about what's reasonable, under what circumstances, how much authority an officer needs to justify each kind of stop, what that stop allows them to do, and what rights you retain throughout each one. I want to be upfront about something, because I think it's important to say directly, rather than bury in a quick disclaimer. General legal education, including everything we do here, has real limits. And it's worth understanding exactly where those limits are. What we can do here is give you a strong, accurate, genuinely useful foundation, the kind of understanding that changes how you experience a real situation when it happens. What we can't do here is account for every specific variation, every local nuance, every unique detail of your particular circumstances, because that's simply not something general content is built to do, no matter how thorough it tries to be. That's exactly why the foundation matters so much, though. A strong general understanding is what tells you when a situation is straightforward enough to handle with what you already know, and when it's specific and serious enough that it's worth bringing in someone who can look at your exact circumstances directly. All right, keeping that framing in mind, let's get into it. 1. There are, broadly speaking, three kinds of encounters you can have with law enforcement in a public or semi-public setting, and understanding all three, not just the two named in the title, gives you the complete picture you need to navigate any of them correctly. The first kind is a consensual encounter. This is a voluntary interaction. The officer approaches you, maybe asks you a question, maybe asks where you're headed or what you're doing, and you are under no obligation whatsoever to participate, answer, or stay. You can simply say, politely and calmly, "Am I free to go?" And if the answer is yes, you can walk away. The critical thing to understand about a consensual encounter is that no reasonable suspicion is required to initiate it, no probable cause is required, and no legal justification of any kind is needed, because the interaction is entirely voluntary. Officers can approach anyone and start talking. What they cannot do in a consensual encounter is order you to stay, demand identification in most states without further legal basis, or treat your decision to walk away as itself suspicious. If the answer to, "Am I free to go?" is yes, you are free to go, and the encounter ends there on your terms. The second kind is a detention, also called an investigatory stop, or in legal terminology, a Terry stop, named after a foundational Supreme Court case called Terry versus Ohio, decided in 1968. A detention is not a consensual encounter, and it's not an arrest. It's a middle category, a brief, temporary seizure of your person that an officer can conduct without probable cause for an arrest, but which still requires something specific to justify it legally. That something specific is called reasonable articulable suspicion, and unpacking what those three words actually mean together is one of the most important things this video is going to do, because the line between a valid investigatory stop and an unlawful one runs directly through that phrase. The third kind is an arrest, and an arrest requires probable cause, a higher legal standard than reasonable articulable suspicion, one that requires the officer to have sufficient facts to support a reasonable belief that a specific person committed or is committing a specific crime. An arrest carries with it a different set of rights, different procedural requirements, and a fundamentally different legal situation, and the moment you understand you've crossed from detained to arrested, or from a consensual encounter to a detention, is the moment that changes everything about what you should and shouldn't say. Let's spend real time on reasonable articulable suspicion, because this is the legal concept that determines whether a detention is lawful in the first place, and understanding it changes how you see almost every version of this scenario. Reasonable articulable suspicion means exactly what it sounds like, and all three words matter equally. Reasonable means it has to be based on something more than a gut feeling or a personal preference. It has to be the kind of suspicion a reasonable person with the same training and information would also form. Articulable means the officer has to be able to put it into words, to describe specifically what they observed or knew that led to the suspicion, not just say, "something seemed off," and leave it there. And suspicion means it's a lower bar than certainty, lower even than probable cause. It doesn't have to be a belief that a crime is being committed, just a reasonable basis to suspect that one might be, that the person might be connected to one, or in the classic Terry stop context, that the person might be armed and dangerous. This last piece of the Terry stop framework is worth understanding in its own right, because the original Terry case was specifically about an officer who observed what looked like casing behavior for a robbery and had reason to believe the men might be armed. The Supreme Court held that officers could briefly stop a person based on reasonable, articulable suspicion and conduct a limited pat-down of the outer clothing for weapons, a frisk, if there's specific reason to believe the person might be armed and dangerous. The frisk allowed under Terry is not a full search. It's a pat-down of the outer clothing, specifically oriented toward finding weapons, not contraband, not evidence of an unrelated crime, just weapons, and only to the extent necessary to determine whether the person is armed. This distinction between what a Terry frisk allows and what a full search would allow matters enormously, because officers sometimes treat a lawful detention as license to search more broadly than the law actually permits, and knowing exactly where the line is means you know when something has gone beyond what's authorized. Now let's talk about what happens during a detention specifically, because the sequence of the moment matters just as much as the underlying legal theory, maybe more so for the practical purpose of protecting yourself in real time. When an officer says some version of, "You're being detained," or "Stop right there," or "I need you to stay here," any language that makes clear this is no longer a voluntary encounter and you're not free to leave, the situation has changed in a specific way. You have been seized in the constitutional sense. That seizure needs to be justified by reasonable, articulable suspicion to be lawful. And from that point forward, a very clear set of principles applies. Principles that are worth knowing so thoroughly that they're available to you instantly, under pressure, without having to think through them from scratch. The first principle is this: you have the right to remain silent, and you should use it. This is probably the single most repeated piece of legal advice in the English-speaking world, and it is repeated that often precisely because it is that important. During a detention, you are not required to answer questions beyond, in many states, providing your name, and in some states, proof of identity, and we'll come back to that important wrinkle in a moment. You are not required to explain where you're going, where you're coming from, what you were doing, who you were with, what's in your pockets, or anything else. Anything you say can be used against you, and the relevant thing to understand here is that this isn't just a formal warning, it's a literal description of how the legal process works. Statements made to police during a detention are admissible evidence. They can form part of the basis for an arrest. They can be presented to a prosecutor. They can come up in court. There is no version of a voluntary explanation given during a detention that reduces your legal risk, and there are many versions that increase it significantly. The second principle is this: you should ask clearly and calmly whether you're being detained or whether you're free to go. This is the question that clarifies which of those three categories, consensual encounter, detention, or arrest, you're actually in. If the officer says you're free to go, the encounter is over and you can leave. If the officer says you're being detained, the situation has shifted, and everything that follows is governed by the rules of a lawful detention, including the requirement that it be based on reasonable, articulable suspicion. If the officer says something ambiguous, "Just stay here a second," or "I just need a minute of your time," asking directly whether you are free to leave forces a clear answer, and that clear answer matters, because without it, the legal status of the encounter remains murky in a way that typically doesn't favor you. The third principle is this: stay calm, stay physical, stay still. Do not run, do not argue, do not make sudden movements that could be interpreted as threatening or as an attempt to flee. None of this is about submission to an unlawful stop. It's about the simple, practical reality that contesting a detention is something that happens in a courtroom with an attorney, examining whether the reasonable, articulable suspicion actually existed, not something that happens productively in the street, in the moment the detention is occurring. The legal fight, if there is one, happens later. The goal in the moment is to preserve your safety, preserve your rights by staying silent, and make sure nothing that happens gives anyone additional justification for escalating. The fourth principle is this: do not consent to anything. Not a search of your person, not a search of your bag, not a search of your car if you happen to be near one. We'll come back to consent in detail because it deserves its own careful treatment, but the short version is that consent transforms a potential Fourth Amendment violation into something you voluntarily allowed, and that transformation makes the evidence that results much harder to challenge later. Saying "I don't consent to a search," clearly, calmly, once, is not obstruction, is not escalation, and is not an admission of anything. It is a statement of your legal position, and it preserves your ability to challenge what follows, if what follows goes somewhere you didn't want it to go. Now let's talk about that identification question specifically, because this is one of the more genuinely complicated wrinkles in this area of law, and it trips people up regularly. A number of states have what are called stop and identify statutes. These laws require you to provide your name, and in some cases, additional identifying information to an officer who has lawfully detained you, meaning an officer who has reasonable, articulable suspicion justifying the stop. The Supreme Court upheld the constitutionality of these statutes in a 2004 case called Hybel v. 6th Judicial District Court of Nevada, holding that requiring someone to identify themselves during a lawful investigatory stop doesn't violate the Fifth Amendment's protection against self-incrimination when simply providing a name isn't incriminating by itself. The important details here are several. First, not every state has a stop and identify statute. Approximately half of states have some version of these laws, and about half don't, which means the obligation to identify yourself during a detention depends heavily on where you are. Second, even in states with stop and identify statutes, the obligation typically only applies during a lawful detention. If the stop itself wasn't lawfully justified by reasonable articulable suspicion, the identification requirement doesn't cleanly attach. Third, in most states with these statutes, the obligation is to provide your name, and sometimes a date of birth or address, not to answer additional investigative questions, not to explain what you were doing, not to consent to a search. Identifying yourself and submitting to interrogation are different things. Fourth, in states without stop and identify statutes, you generally have no obligation to provide even your name during a detention, though as a practical matter this distinction can be harder to navigate in the moment than it is to describe in a script. And consulting with an attorney familiar with your specific state's approach in advance is genuinely valuable. The practical takeaway is this: know whether your state has a stop and identify statute before this moment ever arises, because the answer changes your specific obligations in a specific situation that could happen at any time. If you're in a stop and identify state, providing your name when lawfully detained generally avoids the additional complication of being arrested specifically for refusing to identify, which is a real possibility in those states. If you're not in a stop and identify state, you have more latitude, though the same general principles about staying silent otherwise still apply. Now let's talk about how a detention becomes an arrest, because that transition, when it happens, is one of the most important moments in the entire encounter, and recognizing it correctly matters more than almost anything else. A detention is supposed to be temporary and limited in scope, long enough to investigate the suspicion that justified it, not longer. Courts have held that a detention becomes unreasonably prolonged if it lasts significantly longer than necessary to address the basis for the initial stop, and at some point, a prolonged enough detention becomes a de facto arrest that requires the higher standard of probable cause to be lawful. But the more common way a detention becomes an arrest is straightforward. The officer decides they have probable cause based on what they've observed, what they've found, what someone said, or what they've checked through their dispatch system, and they tell you, in some form, that you're under arrest. When that happens, everything changes, and the change has to be recognized immediately because it triggers a different and more complete set of rights. You have the absolute right to remain silent. Not a modified version of this, not a right to explain yourself helpfully, not a right to tell your side of the story, now before things get worse. The absolute, complete, total right to say nothing at all, beyond asking for an attorney. This matters more in the moments immediately following an arrest than perhaps any other moment in the entire encounter, because the temptation to explain, to clarify, to provide context, to demonstrate cooperativeness, to say something that will make this make sense, that temptation is extraordinarily powerful, precisely when it is most dangerous to yield to it. You have the right to an attorney, and you should invoke it explicitly and clearly as soon as you know you're under arrest. The specific language matters here, because the Supreme Court's decisions in this area have drawn a meaningful distinction between vague or ambiguous references to wanting a lawyer and a clear, unambiguous invocation of the right to counsel. Saying maybe I should talk to a lawyer, or I think I probably need an attorney at some point, is not the same, legally, as saying I want a lawyer and I'm not answering any questions until I have one. The clearer, more direct version is the one that triggers the full protections. It requires officers to stop questioning you, and any statements obtained after a clear, unambiguous invocation of the right to counsel are generally inadmissible. This is too important to leave ambiguous. If you're under arrest, say clearly, I am invoking my right to remain silent and I want an attorney. I will not be answering any questions. You have the right, in most circumstances, to be informed of why you're being arrested. Knowing what you're charged with matters, not just emotionally but practically. It's information that goes to your attorney immediately, and it's the beginning of understanding the full shape of your legal situation. You have the right, under Miranda as most people know it, to be warned that anything you say can and will be used against you, that you have the right to remain silent, that you have the right to an attorney, and that if you cannot afford an attorney, one will be appointed for you. The timing of these Miranda warnings matters in a specific, often misunderstood way. Miranda warnings are required before custodial interrogation, meaning before officers question you while you're in custody. They're not required the moment handcuffs go on, and failure to give them doesn't automatically make an arrest unlawful. What it does is generally make statements obtained in violation of Miranda inadmissible as evidence. The arrest itself can still stand. The statements can't be used. This is why the best approach is to invoke your rights immediately and explicitly, rather than waiting to see whether the Miranda warning is formally given to you. Now let's talk about one of the most psychologically difficult aspects of this entire situation, because it's important to name it directly, rather than skipping past it as though the only challenge here is knowing the law. Human beings are wired for social reciprocity. When someone asks us a question, we feel an almost physiological pull to answer it. When someone in authority asks a question, that pull becomes stronger. When someone in authority asks a question in a high-stress situation while we're worried about what happens if we seem uncooperative, that pull becomes nearly overwhelming, and it shows up even in people who absolutely know better, people who have studied this, people who have thought about it in advance. This is not a personal failing. It's a deep feature of human social cognition that law enforcement interview training is specifically designed to work with and around, and understanding that your instinct to explain yourself is going to be working against you in that exact moment is the most important preparation you can do. The hardest part is not knowing the right words to say. The hardest part is resisting the almost physical urge to fill the silence with something, anything, that might make the situation feel less threatening or help the officer understand that you're a normal, reasonable person who has nothing to hide. And the single most important thing to know about that urge is this: it doesn't help you. Not once. Not in any version of this scenario. Not under any circumstances. Innocent people have been convicted partly on the basis of voluntary statements made in exactly this kind of moment, not because they lied, not because they confessed, but because they tried to explain, and their explanation introduced facts that didn't perfectly hold up under the pressure of a full investigation. Staying silent when you're detained or arrested is not suspicious. It is the single most rational, protective thing you can do, and every attorney who has ever represented a criminal defendant will tell you the same thing. Let's talk about consent specifically now, because the way consent works during a detention is genuinely important and genuinely misunderstood. When an officer asks, "Do you mind if I search your bag?" or "Can I take a look at what's in your pockets?" during a detention, they're asking for consent. They might not be asking in a way that sounds optional. It might be phrased as a statement almost, a kind of assumed cooperation, but it is legally a request for consent, and consent has to be given voluntarily to be valid. The problem is that courts have repeatedly held that consent can be voluntary, even in situations that don't feel entirely voluntary, even in situations where the person felt some degree of pressure, because the standard is not whether you felt free from all pressure, but whether a reasonable person in your position would have felt free to refuse. And the best way to establish unambiguously that you didn't consent is to say so clearly, "I don't consent to a search." You're allowed to say this even while understanding that the officer might have independent legal authority to search in some circumstances, if they have a warrant, if there's probable cause, and exigent circumstances, if you're being arrested, and the search incident to arrest doctrine applies. Saying "I don't consent" in any of those situations doesn't stop the search from happening, but it means the legal foundation for the search has to be something other than your agreement, and that distinction matters enormously when an attorney is looking at the case later and asking how that evidence was obtained. The difference between the defendant consented and the officer conducted a search incident to arrest is a meaningful legal difference, and it's worth preserving. There's something worth understanding about the search incident to arrest doctrine specifically, because it comes up often, and it can feel like it gives officers unlimited authority to search everything around you the moment you're arrested, which isn't quite how it works. When you're lawfully arrested, officers are generally permitted to search your person and the area within your immediate reach, what courts call the area within your immediate control, as part of that arrest. The legal justifications for this are officer safety and preventing the destruction of evidence. What the search incident to arrest doctrine does not authorize is a full search of your home simply because you're arrested inside it, a full search of your car simply because you're arrested near it in all circumstances, or a search of areas you clearly couldn't reach and that serve no officer safety purpose. The scope of a lawful search incident to arrest has been defined and limited by case law, and while it does give officers real authority to search on arrest, it doesn't give them unlimited authority to search everything in the vicinity simply because the arrest is occurring. Let's talk about something that comes up in almost every real version of this scenario and almost never in the theoretical version. What happens when you think the stop itself wasn't lawful, meaning you don't believe the officer had reasonable articulable suspicion to detain you in the first place? This is one of the most important moments to handle correctly, because the instinct is to argue, to demand justification, to ask what exactly gave the officer the right to stop you, and while that instinct is understandable, acting on it in the street in the moment of the stop is almost never productive and is sometimes actively harmful to your legal position. You're allowed to ask what is the basis for this stop calmly and clearly, and the answer, or the lack of one, becomes part of the record of the encounter. But the appropriate place to contest an unlawful stop is not the sidewalk. It's a courtroom where an attorney can examine the full circumstances of the stop, challenge whether reasonable articulable suspicion genuinely existed, and potentially get evidence that resulted from the stop suppressed under what's called the exclusionary rule. The exclusionary rule is one of the most powerful tools available to challenge unlawful police conduct, and it exists specifically for situations like this. If officers stop you without reasonable articulable suspicion, and in the course of that unlawful stop they find something they wouldn't otherwise have found, the exclusionary rule and its fruit of the poisonous tree doctrine can potentially render that evidence inadmissible, meaning it can't be used against you in court. But this entire legal strategy depends on the stop having been properly contested in the right venue, through the right process, with documentation of what actually happened. Arguing in the street, and potentially giving officers additional justifications for escalating the encounter is not the same as contesting the stop legally, and confusing the two is a mistake that can make your situation significantly worse. The clear separation to hold on to is this. Your job in the moment of the stop is to comply physically, stay silent, clearly invoke your rights, clearly decline consent, ask if you're free to go or are being detained, and observe everything you can so you can document it afterward. Your attorney's job, afterward, is to determine whether the stop was lawful, whether your rights were violated, and what legal remedies are available if they were. Let's talk about what you should do immediately after a detention or an arrest ends, or if you're released at the scene after a detention, because the period right after the encounter is as important as the encounter itself in many ways. Write down or record everything while it's still fresh. Everything. The time, the location, how many officers were present, their badge numbers or names if you could see them, the exact words used, what the stated reason for the stop was, what was searched if anything was searched, what was said by whom in what order, whether you were given Miranda warnings and when, whether you asked for an attorney and what the response was, whether you stated clearly that you didn't consent to anything. Memory fades extremely quickly, especially after high-stress situations, and contemporaneous documentation, notes made as close to the event as possible, carries significantly more weight and credibility than recollections produced weeks later when a legal challenge is being assembled. If you believe your rights were violated, contact an attorney, specifically a criminal defense attorney or a civil rights attorney depending on the nature of the violation, as quickly as possible. There are deadlines involved in filing certain kinds of challenges and complaints, and the earlier you begin that process, the better position you're in. Even if you ultimately decide not to pursue a legal challenge, talking to an attorney helps you understand exactly what happened, what your rights were, and whether there are options available to you that you might not have known about on your own. Let's talk about the specific scenario of a traffic stop, because this is the most common context in which most people will encounter a detention, and it has a few details specific to it that are worth understanding carefully. When an officer pulls your car over, that is a detention from the moment you stop. The officer needs reasonable articulable suspicion, typically a traffic violation they observed, to justify the stop. From that point, the same general principles apply. You have the right to remain silent beyond providing your driver's license, vehicle registration, and proof of insurance, which you are required to provide in virtually every state. You should state clearly that you do not consent to a search of your vehicle if the officer asks. You should ask if you're free to go before exiting the car at the officer's direction if you're not sure whether you're being detained. Though practically speaking, an officer asking you to step out of the car during a traffic stop has been specifically authorized by the Supreme Court, regardless of whether there's specific suspicion about you personally. So that particular instruction is one you should comply with. The Rodriguez case, decided by the Supreme Court in 2015, established an important limit on traffic stops. Specifically, officers cannot extend the duration of a traffic stop beyond the time reasonably necessary to complete the tasks associated with the stop, running your license, writing the ticket, running the plates, without independent, reasonable, articulable suspicion of something beyond the original traffic violation. If an officer has completed everything associated with the traffic stop and is prolonging it specifically to wait for a drug dog or to try to develop a basis to search the car, that extension is potentially unlawful, and noting clearly in your documentation of the encounter when the original stop appeared to be complete and when the extension began becomes relevant information for a later legal challenge. Let's talk about Terry stops and race. because this conversation isn't complete without addressing the documented reality of how stop and frisk and investigatory stop practices have operated in practice, and for whom the risk of a detention is statistically higher. The use of Terry stops has been extensively documented as disproportionately affecting Black and brown individuals, a pattern so consistent and so widely documented that it produced a landmark federal ruling in Floyd v. City of New York in 2013, finding that New York City's stop and frisk program, as implemented, violated the 4th and 14th Amendments through its pattern of racially discriminatory application. Race alone is not a constitutionally valid basis for reasonable articulable suspicion. The Supreme Court has been clear on this. And a stop justified purely or primarily on the basis of someone's race is not a lawful Terry stop. If you believe a stop was racially motivated or was justified primarily on the basis of your race, this is specifically worth documenting and worth raising with an attorney, because it goes to the constitutional validity of the stop itself. This is also why all of what we've covered in this video matters not only for individual interactions, but for the larger pattern those interactions aggregate into. Knowing your rights protects you individually in the moment. Documenting violations, challenging unlawful stops, creating a record of unconstitutional conduct. That's what shapes how these powers are used more broadly, over time, across the full range of people they affect. Let's talk about a scenario worth walking through specifically, because it illustrates several of these concepts at once. You're walking down the street, you see an officer moving toward you. They make contact and say they'd like to talk to you about something that happened nearby. This is a common entry point for encounters that can move through multiple categories depending on what happens next, and walking through the sequence helps clarify how all of these principles actually apply in a real, fluid situation. At first contact, if the officer hasn't done or said anything that would make you feel you're not free to leave, this is a consensual encounter. Your first move, if you want to test that, is to ask calmly, "Am I free to go or am I being detained?" If you're free to go, you leave. If the officer says you're being detained, the situation shifts to Category 2, and everything we've covered about detentions now applies. In the detention phase, you provide your name if your state has a stop and identify statute, and you're willing to comply with it. You say nothing else, you do not consent to any search, and you observe and remember everything you can. If the officer articulates a specific basis for the stop, something they claim to have observed, some reported incident nearby, that articulation becomes relevant later to whether the stop was actually justified. If they don't articulate one clearly, that's also relevant and worth noting. If the situation escalates and the officer says you're under arrest, the category shifts again, and everything we've covered about arrests now applies. You invoke your rights clearly and completely. I am invoking my right to remain silent, and I want an attorney. I will not be answering any questions. You do not argue, you do not explain, you do not try to talk your way out of the situation in the street. You comply physically with the arrest while clearly declining to consent to anything, and you preserve every legal option for afterward by saying nothing further until you have legal representation. Let's talk about the specific situation where you're detained, and then the officer brings in a K-9 unit, because this comes up often enough and carries enough legal complexity to deserve its own treatment. Following the Supreme Court's decision in Illinois v. Caballes in 2005, the use of a drug-sniffing dog during a lawful traffic stop, during the time the stop would otherwise take to complete, is generally not considered a Fourth Amendment search. However, the Rodriguez case we mentioned earlier established that prolonging the stop specifically to conduct or wait for a dog sniff, beyond the time necessary to complete the stop's original purpose, does require independent, reasonable, articulable suspicion. So the question of whether a dog sniff is lawful in your specific situation depends heavily on the timing. Was the stop already complete or substantially complete, and was the extension specifically to deploy the dog? If so, and if there wasn't independent reasonable suspicion justifying that extension, the results of that sniff, and any search that followed, may be challengeable. More recently, in Florida v. Jardines decided in 2013, the Supreme Court held that bringing a drug dog to the front porch of a home to sniff for drugs without a warrant is a Fourth Amendment search, which gets us back into home territory briefly. The home, even just the porch of a home, carries stronger protection than a public sidewalk or the exterior of a car stopped on a public road. Let's talk about something that doesn't get discussed enough in these conversations: what role prosecutors play, and why what happens during a detention or at an arrest matters as much as it does to what happens months later in a courtroom. Prosecutors decide whether to charge, what to charge, and how hard to fight those charges, and the decisions they make are influenced significantly by the evidence they have available. Every statement you make during a detention or after an arrest is potential evidence. Every piece of evidence obtained in a search, whether that search was lawful or not, is something the prosecutor will consider. The challenge to an unlawful stop, an unlawful search, an involuntary statement happens in a pretrial motion, what's called a suppression motion, where a defense attorney argues that certain evidence should be excluded because it was obtained in violation of the Constitution. If that motion succeeds, the prosecutor may suddenly find their case significantly weaker, and charges may be reduced or dropped. If the motion fails, the case proceeds with all the evidence intact. This entire sequence, from the moment of the stop through the suppression hearing, through the trial if there is one, depends fundamentally on choices made in the first seconds and minutes of the encounter. Did you consent to the search? Did you make statements that now need to be explained? Did you invoke your right to counsel clearly and early? Did you document the encounter immediately afterward? These aren't abstract legal questions. They're the specific, practical choices that determine how strong the prosecution's case is and how many options a defense attorney has to work with. The more you know in the moment, the better every decision point goes. Let's talk about what happens when things go wrong in a stop. Not just in terms of your legal rights being violated, but in terms of the encounter becoming physically threatening or dangerous, because this is the most serious version of this scenario, and it deserves a direct, honest treatment. If you believe an officer is acting unlawfully, an unlawful stop, an unlawful search, conduct that exceeds what they're legally authorized to do, the principle we've already covered applies in its strongest form. Do not physically resist, even if the resistance would be legally justified in a technical sense. The reason for this is brutally practical. Legal justification for physical resistance in the abstract does not protect you in the moment, and the risk of a physical confrontation escalating in ways that endanger your life is real. The courtroom is where the unlawful conduct gets addressed. The street is where your safety comes first. These two things are not in conflict. They're a sequence. Preserve your safety in the moment. Challenge the unlawfulness of what happened later, in the appropriate venue, with the appropriate tools. If you're physically harmed during a detention or an arrest, document the injuries as completely as possible. Photographs, medical records, a detailed written account, and contact both a criminal defense attorney and a civil rights attorney immediately. Claims under 42 U.S.C. Section 1983 allow individuals to sue government officials, including law enforcement officers, for constitutional violations. And the existence of injuries and a documented record of what caused them is the foundation of any such claim. Let's talk about what to do if you witness someone else being detained or arrested, because this scenario comes up, and people frequently don't know what their rights and obligations are as an observer. You generally have the right to observe and record law enforcement activity in a public place, and the First Amendment protection for recording police performing their duties in public has been recognized by multiple federal circuit courts. You are not required to stop recording simply because an officer tells you to, though if an officer orders you to move back or to a specific area, complying with that instruction while continuing to record from the permitted distance is generally the better approach. The right to record doesn't include the right to physically interfere with an ongoing law enforcement action, and being in a position where you could be interpreted as interfering is something to avoid. What you should not do is insert yourself verbally into someone else's detention in a way that could be characterized as interfering with police duties. You can observe, you can record, you can make a note of what you saw and document it afterward. You can share what you saw with an attorney or with civil rights organizations that track this kind of conduct. What you generally should not do is intervene physically or verbally in ways that could give officers a basis to expand the stop to include you. Now let's talk about something that ties all of this together and is worth dwelling on specifically before we start wrapping up, because it's the underlying practical architecture that makes all of these individual pieces work together. Everything we've covered in this video, the right to remain silent, the right to an attorney, the right to be free from unreasonable seizures, the distinction between a detention and an arrest, the requirement of reasonable articulable suspicion, the requirement of probable cause, the exclusionary rule, suppression motions, all of it connects back to a single foundational idea. These rights exist to be used, and they work by being invoked, specifically and clearly, in the moments that matter. They don't protect you automatically simply because they exist in the text of the Constitution. They protect you because you exercise them, because you say the right words, because you create a clear record that you asserted your rights and did not voluntarily waive them, and because an attorney can later use that record to challenge what happened. This is why preparation matters more than almost anything else for this kind of scenario. Not because you should be paranoid about law enforcement interactions or expect every encounter to become a constitutional crisis. The vast majority don't. But because the encounters that do become legally significant become so precisely because the person in the middle of them was caught off guard, didn't know which category they were in, said things they shouldn't have said out of social instinct, consented to things they had every right to decline, or failed to invoke rights that would have changed the course of everything that followed. The preparation happens now, in a comfortable, calm moment, so that if this situation ever actually arrives, you are not learning the rules in real time while someone is waiting for your answer. Let's walk through the exact words one more time, because having them precise and ready is the whole point. When you want to know whether you're free to leave, am I free to go, or am I being detained? Calm, direct, no elaboration needed. When you're being detained and asked questions, I'm invoking my right to remain silent. I'd like to know why I'm being detained. That's it. You don't add to it. You don't explain why you're invoking it. You don't soften it with an apology. You say it and you stop. When an officer asks to search you or your belongings, I don't consent to a search. Clear, once, not repeated endlessly, just stated clearly so it's on record. When you're under arrest, I am invoking my right to remain silent and I want an attorney. I will not answer any questions until I have an attorney present. Specific, unambiguous, not softened, not qualified. You can say this politely, you can say it without hostility, but every word in it needs to be there exactly as stated. When you want to document the stop afterward, write down or voice record everything as quickly as possible after the encounter ends, while your memory is freshest. Time, location, how many officers, names or badge numbers if visible, the exact words used for the stop's justification, what was searched, if anything, what was said, and in what order, whether Miranda was given and when, whether you asked for an attorney and what the response was. 4 sentences and a documentation checklist. That's the practical core of everything in this video, and those 4 sentences, said calmly and precisely, protect you far more comprehensively in almost any version of this scenario than any amount of explaining, cooperating, or hoping for the best ever will. Let's talk for a moment about the specific situation of being a passenger in a vehicle that's been stopped, because passengers have a set of rights that are slightly different from the drivers and worth understanding specifically. As a passenger in a vehicle that's been stopped, you are also, generally speaking, seized for Fourth Amendment purposes the moment the car is pulled over. You're not free to simply get up and walk away from a traffic stop without the officer's permission, and courts have recognized this. If you're a passenger, you have the same right as the driver to be free from an unlawful prolonged stop. All right, that's where we'll leave it for today. I hope this gave you something genuinely useful, not just interesting to hear, but something you could actually use if the right situation ever came up. That's always the real goal here, understanding you can actually carry with you, not just information you forget by tomorrow. Take care of yourself, know what's actually yours, and I'll see you in the next one.